All right, everybody. Good morning. It's Bernard Nomberg. It's Tuesday. It's 10 a.m. Central. And it's our weekly Nomberg Law Live. I've been doing this for almost 5 years now, and I love to have interesting conversations with people in their areas of expertise. And my guest this week is longtime friend and colleague Jack Jacobs, Birmingham area attorney. Jack, good morning, and thank you for making some time for us today.
Good morning, Bernard. I appreciate you having me on. It's looking forward to it.
My pleasure. And guys, for those of you who don't know Jack or his firm, Jack does a little bit of the same kind of work that Dave and I do in the work comp realm, but he also does some things that I think are, for our part of the country, very important because he deals with coal miners and the unique types of cases that they have. Their firm also does railroad cases. But before I trample all over what your firm actually does, Jack, share a little bit about your practice and your firm.
Oh, sure. We do, like you said, a lot of work for coal miners. We work with the United Mine Workers here in Alabama, part of District 20. So we have a good relationship with those, the men and women there. A lot of that involves, like you said, workers' comp type cases, other mining accidents, and then a lot of what we do is federal black lung claims on top of that. We also do, like I said, railroad work, which involves the railroad, basically the workers' comp system for railroad employees, and then whistleblower type claims where people are retaliated against for basically asserting their safety rights as railroad employees. So it's a lot of what we do.
And for folks who don't know, the type of work that David and I predominantly handle are state of Alabama workers' compensation cases, people who are employed in the private sector, not state of Alabama employees and not federal employees. And that's where we're headed with our conversation today with Jack for some of it. When you deal with railroads, that's its own separate entity of laws. And when you deal with underground coal miners, you again may be dealing with a set of federal laws. So Jack, I guess let's start there. What are the typical injuries, medical conditions, and cases that involve underground coal miners?
I think some of it is a lot similar to just general workers in heavy industrial settings. You've got back injuries, torn rotator cuffs, different orthopedic type injuries that you see. These people are working in generally pretty heavy conditions underground, but they're working, they might travel 1,800 feet down an elevator shaft and then take a car or personnel carrier 10 miles underground to get to their workplace, which is just really hard to just really wrap your head around.
I want to tell you, I had an opportunity many years ago to go do one of those tours for a case that we had when I was a baby lawyer. I couldn't do it. I could not, I guess the claustrophobic in me or whatever it was, I could not bring myself to go down there. Have you had an occasion to go 10 miles underground to view an area where people were working?
I actually had the opportunity last fall in a case that we have where we did travel, like I said, 1,800 feet down the elevator shaft and then get in the car and just ride. It was pretty wild, just imagine. And we were kind of a conversation about it. It was a mine in Brookwood. And I was like, well, is there some other place to get closer? And there are other entrances to the mine. And they said, yes, we can do that, but it's an hour and a half drive to get there. Just like, so,
wow.
Yeah.
It does take a special mindset to do that type of work. But I interrupted you, Jack, and I'm sorry. Let's go back. A lot of the underground type cases can be handled through our state work comp system, but there are also other types of conditions that have to be handled through a federal set of laws, particularly when it comes to what's called black lung and the like. So I kind of want to focus, if you will, give us an example of a typical case that you guys handle dealing with that set of laws, and we'll kind of work through that for a few minutes.
Sure. The federal black lung program is a especially federal workers' compensation type program, and there are a few different ones but the ones we see here in this part of the state are primarily for black lung claims. So this is a workers' compensation program through the federal government, but it works a little bit differently in the sense that these are what I would describe as all or nothing claims. Either you're entitled to benefits or you're not, in the sense that, if you have a state workers' compensation claim, you might have partial disability, or you can resolve the claim short of, trial, basically. Most of these federal black lung claims are litigated, and you only win if the minor is proven to be totally disabled due to a respiratory disease.
And how, let's say that someone comes to you and they believe that their medical condition is caused from 20 years of working in that environment. Well, they can certainly testify and show how their conditions are, but that may not be enough in front of a judge or whatever decision maker, arbiter, whatever it may be. Jack, how do you link up the conditions or the symptoms that your client is complaining of to be able to prove a case? How do we show that they have a legit case?
Right. There are a few different ways. Typically, it depends on the length of coal mine employment. In 2010, under Obamacare, they enacted a presumption under the law that says if a coal miner has 15 years or more of underground coal mine employment and a disabling respiratory condition, then they're presumed to have black lung and entitled to benefits.
Wow.
So that basically, if we can prove the disability part, it shifts the burden of proof to the coal operator to prove that they don't have black lung, which is always hard to prove a negative in a legal situation like that.
Well, sure. How important are the historical medical records of your client to be able to prove your case?
I think almost all these cases turn on medical records. It's not testimony alone is not going to get you there in these cases. You've got to have, typically pulmonary records where they've been tested for breathing problems, and there are specific criteria in the regulations that set what is considered disabling in those records.
And Jack, when you go to prove your case, and let's say that there is that connection between the medical conditions and working underground, I'm sure one of the questions, I know we get asked this all the time in our cases, is, well, what am I entitled to? How much? What kind of money? What kind of employment, medical care? What are those? I guess what I'm asking is, what are the potential remedies for an underground coal miner in one of the federal black lung cases?
That's a very important question. So right now, I believe the coal miner is entitled to monthly benefits for themselves and their dependents. So if they qualify, then the miner themselves would get about $700 a month in benefits. That is tax-free workers' comp. And then if they're married or have an additional dependent, it bumps up to about $1,080. It just went up the first of the year, so I'm not exactly sure what the exact number is, but it's about that much each month. And typically it runs from the date that they apply, the month they apply, for as long as they're alive. And so if they get benefits for themselves, so if the miner's awarded, under the law as it's written right now, the spouse continues to get benefits without having to reproof her claim, or his claim, I guess. So that's a nice feature. It would drop down to $700 a month now, and they get their medical benefits as well. They get a medical card to pay for all the treatment they get.
Can there be situations, Jack, where someone has proven their disability, the relationship between the conditions and the working conditions and their medical situation, but still be able to work either in the mining world or in some other employment setting? Or is it one of those situations where once you prove it and you're considered to be disabled through this federal black lung set of laws, that you're done working?
I think that's primarily the case there, that you are done working. I've had a few cases where individuals are working in fairly low, what we would consider sedentary type jobs, or maybe light duty, not necessarily working in the coal mining, heavy duty job, where they have been able to draw both, but that's not very frequent.
Jack, I've got a question that was just submitted. The question was, what about someone who is a smoker, whether it's cigarettes or whatever kind of tobacco? Does that impact the cases? Does it sometimes prevent a coal miner who has black lung from getting benefits?
That often comes up a lot. It depends on the length of employment of the coal miner. Typically, if the miner has 15 years or more of underground employment or above ground employment in similar conditions, is how the law phrases it, they still have to prove that the coal mine dust exposure plays no part in the disability. So even if they have the lengthy smoking history, the employer still has to exclude the impact of coal mine dust exposure on the impairment.
And I'm sure that's a very high burden for the employer once or after you've already proven your connection through the different criteria. Guys, I'm talking to Jack Jacobs, a friend of ours, a local attorney. His firm handles not only work comp cases like Dave and I do, but they also handle federal black lung cases for underground coal miners. And before we pivot to some railroad discussion, Jack, are there any other things that might be of importance to underground coal miners, the typical questions maybe that you're asked on those first telephone conferences or meetings with prospective clients? Anything of significance that you hear quite often?
I think the most important thing is that it doesn't cost the coal miner anything to do this other than time. We don't charge the coal miner for whatever time we spend in the case, and they don't pay us any money out of whatever money they get. So if whatever money is paid to them is theirs, we keep track of our time and we bill the coal company in those cases, and the coal company has to pay us. So it really is a good situation as far as, with the fee shifting statute, basically, and letting the miner keep all the money that they're entitled to.
I wish it was that way in our state work comp cases as well, but I don't know.
Absolutely.
The timekeeping, I think, would be a real pain to me. Guys, again, I'm talking with Jack Jacobs, attorney here in Birmingham. I want to welcome one of my buddies, Mitch Jackson, the Southern California trial lawyer and social media guru. He's on with us. Hey, Mitch, thank you, bud, for stopping by. Jack, one more question before we shift on to the railroad discussion. Are these black lung cases, are they typically tried in a court in front of a judge or a jury, or do you mediate them? How do they get resolved for the most part?
Right. I think it's probably more akin to a Social Security disability hearing in the sense there is an administrative law judge process the Department of Labor uses. And many of those judges do come from the Social Security Administration at some point in time. So it's very similar to that, more relaxed evidence standards that you would see in those cases, but it's very specific to the black lung disease or respiratory impairment, and not just overall disability.
And like Social Security, have those type hearings also moved to either telephone or virtual hearings, or are they still in person?
Yeah, with COVID, they've all gone to basically telephone hearings in the last couple of years, which is, I guess, has been good for us. It has not slowed that process down as much as jury trials or just regular bench trials here have been slowed down. It's been impacted, though.
I've got to say, as a side note, in the Social Security world, where I do also some of my practice, we've actually benefited for our clients with having those telephone hearings, because the hearings seem to be set more quickly, and the decisions coming out seem to also be coming more quickly. So for those regards, those are good things. But I guess the drawback maybe for your clients as well, Jack, if they're just on the phone, is the judge, the ALJ, doesn't get to visually see our clients, to see how impaired their movements are, or how labored their breathing can be. Things like that, I think, are important, But so there's a trade-off
Right.
there. Have you guys noticed that as well?
I would say it's a little bit different. You know, our cases are so much more medically record driven than with the discretion, I guess, you'd have with a Social Security case. So they have to really look at the records and kind of, you know, make something, a determination that correlates to those records as far as disability goes.
Sure.
So you don't have the discretion there. And the other downside for us is these cases are, you know, a decision in a black lung case could be easily 30 pages long. And so they're very intense and very thorough. So it's, and they're not quick. So they take, you know, waiting for a decision for a year would not be unusual.
Wow. I guess I won't complain in the Social Security world when we're waiting 6 weeks or maybe a couple of months.
That'd be nice. Yeah.
Jack, let's pivot for a few minutes. Another area that your firm does such a great job is in representing folks who are employed in the railroad industry and are hurt on the job. Again, it's a workers' compensation claim, or sometimes there are what we call third-party actions, but kind of give us a brief overview. If I'm a railroad worker and I fell off one of the trains or one of the cars that I was working on and I broke my leg, and what type of a claim, how are those typically? What's the process for that?
Typically, you're looking at a claim under FPLA, the Federal Employers Liability Act for railroad employees. It's similar to workers' comp, but it's carved out specifically for those individuals. You know, typically, which is, I think, you know, good for the trained workers. They do get more money than they typically would in a workers' comp case. So there is some more of a factor there. As far as liability, and we do those type of cases all over the Southeast, not just here in Alabama, but around the region.
Are those types of cases handled, again, in front of an administrative law judge or a federal district court judge, or how do you bring those to resolution?
Typically, those are handled in state court, depending on where the injury occurs.
Well, it's you mentioned a few minutes ago about how they get paid a little bit better through that federal law, and I don't want to open up the can of worms that you and I know could take over our show about how low the state of Alabama work comp pays out. But what we're talking about is federal laws, the FELA, Federal Employee Liability Act cases. And Jack, what are some of the typical types of cases, the injuries, claims that you see in the railroad cases?
You know, I think they're, you know, similar to comp type cases. You're seeing people with lifting type injuries, orthopedic injuries. It just haven't involved trains in these cases. And there are some aspects, it's like I said earlier about some whistleblower cases where people, you know, get hurt doing something and get retaliated against by the employer. We're seeing a lot more of that lately I don't really understand why, if there's just some drive by some of the train operators to try and reduce overhead or manpower, and this is their way of, you know, attritioning these numbers down, is to say, you got hurt, well, you shouldn't have done X, that was the wrong way to do it, so we're going to fire you. And so that's additional protection that they have in those contexts.
Well, in our state court system, contributory negligence isn't, as you know, a defense, meaning if the employee created his or her own accident, whether it was through just sheer negligence or not being trained, those kind of things, that's not going to be a defense in a state of Alabama work comp case. It's a no-fault set of laws. What about in the FELA, in those railroad cases? Can contributory negligence stop a claim, or is that not part of that system of laws?
I don't believe that's that part of that system of laws. I will say that I do not do as much practice in that area as other attorneys in my firm, so I will caveat that, but I don't think that's as strong there as, so I think it's similar to the Alabama law on the workers' comp.
And I kind of thought that it was. I just hadn't handled one of those cases in so long, just because typically we're going to refer them to your firm or one of the other firms that handles that predominantly. Jack, what somebody who gets hurt on the job, whether they're underground in a coal mine or they're working on above ground on a railroad, they get hurt. What typically would you suggest they first do in order to preserve their claim, preserve their health? What are some of the first things that they should really be thinking about? Because, when a trauma happens, the brain goes haywire because you're not used to that environment. Hopefully you got people around you who are more calm, but whether it's the few minutes after you get hurt or the days afterward, do you have any suggestions, any words of wisdom for the injured worker at that point of the process?
Yeah, I think, it's important to be upfront with the doctors and vocal about what's going on with you, making sure the doctors are all aware of what problems you're having when you get injured, to make sure that they're documenting what's going on. You should be taking notes and keeping records on your end about what you see, what you've told people. And I think talking to a lawyer early on is probably a good idea in these cases. These are, can be complicated. The employer is probably going to have a lawyer or at least a very experienced insurance adjuster on their side, making sure that they're doing what they can to keep their exposure to a minimum, which is going to negatively impact the injured worker. And so you need someone on your side who's basically been through the situation before, knows what to expect, and to kind of talk with them and say, look, this is what you need to be doing on your end as the injured worker to make sure that you, one, are treated medically like you should be. You're getting the money that you should be in workers' comp. And three, so that, ultimately, from my perspective, I want these people to get treated, get back to work and get back on their lives and not stuck in a situation where they're not getting what they need to get their life back together. And so let's, call someone call someone you trust and talk to them and say, look, what do we need to do? How do we get back on the road to recovery and maximize those situations?
I like to say that all of life's stresses ramp up when a person gets hurt on the job, because their health is impacted, their livelihood, their employment, and that in turn impacts communication within the family unit, which then it just has a spiraling effect. And Jack, a question that came in is, what about surveillance by private investigators by the insurance company? Do you see much of that in your type of cases? And how should a person act, whether they see the surveillance or not?
It depends on the area. I think in workers' comp, that's been a bigger problem. I say state workers' comp claims, FVLA claims, you're going to see those type of surveillance issues. Not so much in the black lung world have I seen the surveillance come into effect. And it's just, in 9 times out of 10, they're getting pretty mundane stuff I've seen. I remember a case years ago where I had a client, they videotaped walking into Target and walking out, and they were just making a big deal about it. I was like, well, I think people can go to the store, but that's not against the law, even if they are hurt. But just be careful. You don't want to, if you're off work because of a back injury, it's probably not a good time to help your buddy move out of his house, right? Just be sensible and just use your head on those things.
Yeah, it's too easy to do surveillance on people, and they never even have to leave their home to be surveilled. But you're right, it's just use common sense. If a doctor says, don't go out and mow your yard, don't paint your house, and then there's videotape of you painting your house or mowing your lawn against your doctor's, it just kills the credibility
Sure.
of the person. They could have the best or worst injuries in the world, but credibility is just so vitally important. Frankly, a lot of times that's the only person who testifies in front of a decision maker. But guys, we've got just a few more minutes. I'm talking with Birmingham area attorney Jack Jacobs. Jack, I put a link to your firm's website in the show notes. but how can folks call or get in touch with you in case they have a case potentially that they want to discuss with you?
Sure, they can call us at the office at 205-322-2333. There's also a web link, contact us page on our website. You're welcome to email us if you have a question. We'll set up a time to come in and talk about it. That's usually not a problem. So those are probably the best two ways.
Okay. All right, let's pivot. Our last topic, just 2 or 3 minutes. And I didn't even tell him about it, guys, before we went live, but I want to talk about, I know you're an avid runner, Jack, and I want to talk about daily stress. And for me, exercising daily, whether it's for 30 minutes or however long I can go, I just want to move my body. I want to get rid of the day, just kind of wash away everything, put on my tunes or my podcast, whatever it is, and just go. Does running help you kind of separate the day, or is there some other daily things that you do as a busy professional, a dad, a husband, just some guy plugged into everyday life? What do you do that helps you to kind of de-stress on a daily or weekly basis?
I would say your running has definitely been my therapy for the last few years. Just law practice can be stressful in and of itself, and it's hard not to get wrapped up in your clients' problems and have them, stress you out as much as it can for your clients. And so running for me is a good way to get out and kind of maybe think about something else and just decompress. So running for me, I probably typically run 4 to 5 days a week and just try to get out there and relieve some of that stress. And I will say this also, at times it just being out there in your own thoughts, you kind of think through things and problems you've got and kind of work them out in your head, where you're away from the ringing phone, away from the office, just able to just kind of, really concentrate on what's going on and, how to fix it.
For me and for many of us who do what we do, having 30 minutes or an hour or somewhere in between that while we're awake of uninterrupted, just free thought. No phone, no ringing, no texting. I put silent or notifications, I silence all that. And it's amazing how whatever that dedicated period of time is each day, where you can just kind of get lost in no thought or complete thought about whatever. But it's so important because I think a lot of people don't build it into their lifestyle. And I applaud your 4 to 5 days a week. I bet if you could, you'd probably do it every day of the week if your body would let you, or if your schedule would allow for it. But it is, whether you're running, yoga, whatever it may be. Jack, wouldn't you say it's so important for your mental and physical health?
It really is. Just, taking a time you just would have spent wasting on social media or something else, just taking the time each day to just get out there and decompress and get some exercise. That's just been huge for me. So I recommend it fully.
Well, and next Monday afternoon when you go for your run, when this is in podcast form, I highly suggest you put this back on and replay our discussion. But Jack, I appreciate you making some time today and sharing a little bit about black lung cases for underground coal miners, as well as the FELA cases dealing with railroad employee cases. So thank you for sharing a little bit of your expertise and sharing some of your time with us today.
You're welcome. Thank you.
Oh, it's my pleasure. And guys, as you know, every Tuesday at 10 a.m. Central, Nomberg Law Live, we have interesting conversations with people in their areas of expertise. And Jack and his firm do such a fine job and have for many years in those areas. So thank you again, Jack. And thank you all, whether you're watching this live or catch it on replay. Y'all continue to be safe out there, and we'll catch you next Tuesday. Y'all take care.
Thanks. Bye.